Imagine you've lived in the UK for years. You've built a life here, paid your taxes, and you're finally ready to take that last step, applying for British citizenship. But what if a single past mistake, something you thought was long forgotten, could suddenly slam that door shut? In 2025, the rules have changed. The good character requirement for becoming a citizen has been significantly updated, and the consequences are more far-reaching than ever. Stay with me because in this video, we're going to break down exactly what these new updates mean for you. Hello and welcome. The journey to citizenship is a long and often complicated one, and a key hurdle for anyone over the age of 10 is proving they are of good character. But good character isn't defined in the law. The British Nationality Act of 1981 is surprisingly vague on this point. Instead, its meaning is shaped by detailed Home Office guidance given to the caseworkers who decide your fate. And on February 10th, 2025, that guidance was updated, introducing some of the most significant changes we've seen in years. These updates have the potential to exclude a large number of people, especially those who have been recognized as refugees, from ever becoming British citizens. So, what has actually changed? And what does this mean for your application in 2025? We will cover the old rules, the new rules, and what this means practically for things like minor traffic offenses, old debts, and crucially, how you first entered the UK. Before we dive into the new updates, let's quickly recap what the good character test has always looked at. It's not just about avoiding prison. The Home Office takes a holistic view of your life and conduct in the UK. They look at several key areas. First, your criminal record is a major factor. This covers everything from serious offenses to minor ones. We're talking about convictions, cautions, and even fixed penalty notices. Second is your financial soundness. This means your financial affairs should be in order. They can look at issues like bankruptcy, significant unpaid debts, or failure to pay your taxes. An unpaid NHS debt of over £500, for example, could be a red flag. Third is the matter of deception and dishonesty. This is absolutely critical. Have you ever lied or tried to conceal information in any dealing with a UK government department, like on a previous visa application or a benefits claim? This can lead to an automatic refusal and a potential 10-year ban on reapplying. Finally, they consider immigration-related matters. This includes things like overstaying a visa or working in breach of your conditions. This has always been a complex, discretionary assessment. But the February 2025 update has removed a lot of that discretion in one specific and very controversial area. This is the most important part of our video today. On February 10th, 2025, the Home Office published new guidance that fundamentally changes how it treats applicants who entered the UK illegally. Here is the exact wording, and it's crucial. Any person applying for citizenship from 10 February 2025 who previously entered the UK illegally will normally be refused, regardless of the time that has passed since the illegal entry took place. Let's break down why this is such a massive shift. Before this date, the guidance was different. Under rules in place since 2022, an immigration breach like illegal entry that happened more than 10 years ago could often be disregarded, especially if you had since been granted indefinite leave to remain and had kept a clean record. There was a clear path forward. That path has now been closed for many. The new guidance states that for any application made after February 10th, 2025, it doesn't matter if the illegal entry happened 12, 15, or even 20 years ago. It will normally lead to a refusal. The guidance also introduced a new section specifically targeting those who made a dangerous journey to the UK. This includes, but isn't limited to, arriving by a small boat or hidden in a vehicle. Again, anyone who arrived this way without the required entry clearance will now normally be refused citizenship. This has profound implications, particularly for refugees. Many people who are granted asylum in the UK have, by necessity, entered the country without prior permission to seek safety. Under these new rules, despite being lawfully resident for years and recognized as needing protection, they may be permanently barred from becoming citizens. It's important to note the word normally. This suggests there is still some discretion for exceptional cases. The guidance gives an example of someone who entered illegally 14 years ago but was later recognized as a victim of trafficking and granted refugee status. In such a case, a grant of citizenship might be possible, but it's clear this will be a very high bar to clear. So, with these major changes in mind, let's get practical. What does the good character landscape look like for a typical applicant in 2025? First, let's talk about crime. The threshold for refusal based on criminality was already toughened in July 2023. An application will normally be refused if you have a custodial sentence of at least 12 months. But what about minor things? A speeding ticket? A parking fine? The official guidance says that fixed penalty notices, like for speeding, won't normally cause a problem unless you've received numerous ones or you failed to pay, and it resulted in criminal proceedings. However, you must declare everything. Failure to disclose even a minor spent conviction can be seen as deception, which is a far more serious issue for your application. A pattern of repeat minor offenses can be interpreted as a disregard for the law, which is a reason for refusal. So, one speeding ticket might be okay. 5 and 2 years is a problem. Next, your finances. The Home Office wants to see that you are financially responsible. Being in debt won't automatically cause a refusal, especially if you have a repayment plan in place. However, they are looking for red flags. Have you been declared bankrupt? Have you been a director of a company that was liquidated? Have you deliberately and recklessly built up debts? These can all be considered evidence of poor character. And remember to pay your taxes. Unsettled tax liabilities are a major concern for caseworkers. I cannot stress this enough. Be 100% truthful on your application. The Home Office shares information across government departments. What benefits claim where you didn't declare all your income a few years ago? They might find out. That visa application from a decade ago where you embellished your qualifications? It can come back to haunt you. Concealing information is seen as a direct reflection of your character, and it will almost certainly lead to a refusal. So, what can you do to prepare and present the strongest possible case? Let's walk through a simple strategy. First, you should conduct a full character audit. Before you even think about filling out the form, review your entire history in the UK. Gather all documents related to any criminal or civil penalties, financial issues like bankruptcy, or past immigration applications. Be your own detective. Next, you must disclose, disclose, disclose. When you fill out the application, declare everything, no matter how minor you think it is. A spent conviction must be disclosed. A fixed penalty notice should be disclosed. It is far better to explain a minor issue than to be caught hiding it. Then, you need to address potential issues head-on. If you have a potential red flag in your past, a caution, a series of fines, a previous visa overstay, don't just list it and hope for the best. Use a cover letter to explain the circumstances. Provide context. If it was a long time ago, show evidence of your good character since then, such as community involvement or a stable employment history. This is what caseworkers mean when they assess things on the balance of probabilities. It is also vital to get your finances in order. Ensure your taxes are paid and you are up to date with any significant debt repayments. If you have an outstanding NHS debt, resolve it before applying. Finally, you should seek legal advice if you're unsure. This is more important now than ever. If your case is anything but straightforward, especially if you entered the UK without permission, even if it was decades ago, investing in advice from a qualified immigration solicitor is crucial. They can give you a realistic assessment of your chances in light of this new, stricter guidance. The path to British citizenship in 2025 has become narrower. The new guidance on good character, particularly concerning illegal entry, represents a significant hardening of the rules. It signals a clear intention from the government to be much tougher on who gets to become a citizen. The key takeaways are clear. The government is placing immense weight on an applicant's entire history, and past immigration breaches that were once forgivable over time are now, in many cases, a permanent barrier. Honesty and full disclosure are not just best practice, They are your only viable strategy. This can all feel incredibly daunting, but being informed is the best defense. Understand the rules, be meticulous in your preparation, and seek help when you need it. If you found this video helpful, please give it a thumbs up and subscribe to the channel for more updates on immigration and citizenship law. And if you have a question, drop it in the comments below, and we'll do our best to point you in the right direction. Thank you for watching.